Professor of Law at UCLA School of Law. She was previously Chancellor's Professor of Law and Senior Associate Dean for Administration at UC Irvine School of Law. Chacón's research focuses in the field of immigration law, constitutional law, and criminal law and procedure. Her research has been funded by grants from the National Science Foundation and the Russell Sage Foundation. She is a co-author of the 2017 casebook, Immigration Law and Social Justice, and of numerous articles, essays, and book chapters on citizenship, immigration, border control, and human trafficking. Professor Chacón is a member of the American Law Institute. She serves on the Executive Committee of the American Association of Law Schools Section on Immigration, the Ninth Circuit Advisory Committee on Rules of Practice and Internal Operating Procedures, the Advisory Committee of the American Bar Foundation's Future of Latinos in the U.S. Project, and the University of Oxford Board of Criminology's Advisory Group. She is also a Fellow of the American Bar Foundation. Professor Chacón was an associate of the New York law firm of Davis, Polk & Wardwell from 1999 to 2003, after clerking for the Honorable Sidney R. Thomas of the United States Courts of Appeals for the Ninth Circuit. She began her career in law teaching at the UC Davis School of Law, where she received the Distinguished Teaching Award. She has also held appointments as a visiting professor of law at Stanford Law School and at Harvard Law School. She holds a JD from Yale Law School and an AB in International Relations from Stanford University. Would you please join me in welcoming Professor Jennifer Chacón to speak on the topic, Comprehensive Immigration Reform. What does it mean today?
Good morning. Thank you all for being here to discuss this important issue at a very important time in our national conversation about the issue. I want to thank Bob and Elsa for inviting me to be here and for all of the work that you did to get me here and to be in the right place at the right time. I'm really excited to be able to talk about this topic with you. If I get quiet and you can't hear me, please raise your hand and let me know. I think I'm speaking into the microphone, but that may change, so let me know. And if I'm speaking too fast, which my students tell me I have a tendency to do, you should also stop me and let me know. My hope is to speak for a bit and then to reserve some time for questions and answers at the end. And what I am also hoping to do is to note some points where I will not fully elaborate, but can elaborate more if people are interested in the Q&A period. There is obviously a lot of ground to cover when we talk about immigration. And so I viewed my charge today as thinking about sort of major topics in immigration law that require our attention and reflection, and that are potential areas for reform and should be part of a political conversation at this time. So with that, if I could move to the first slide and just give you a sense of where I'm going. That print is tiny. Don't worry if you can't read it. I'm going to tell you what it says. I'm going to start by talking about what the avenues for lawful immigration are right now, sort of what the categories are, how they work, how many people can get in through these categories. And I want to talk about them in some historical context, so giving a sense of where we were and where we've come. And then I want to talk about some of the current obstacles to immigration through these avenues of lawful immigration, some of them a fairly recent vintage, and that could be interesting points of reflection when we think about immigration reform. I then want to focus on our enforcement policies, both border enforcement and interior enforcement, and both federal enforcement and the ways that states and localities participate in that enforcement process, and ask some questions about that, because those are other areas of potential reform. I then want to focus on the federal immigration bureaucracy, thinking here about not just the Department of Homeland Security, but I specifically actually want to focus on immigration courts, the Board of Immigration Appeals, and think about the question of what sorts of resources are going into those agencies, and what sort of political independence do those agencies have or lack, and how might we think about the appropriate structuring of immigration reform. there, and then I'll just close with some bigger picture questions. Start by thinking about sort of the history of immigration control at the federal level, removal of native nations as part of a sort of removal process that has kinship to and relationship to contemporary movements of people. We can think about forced enslavement and the kind of the forced migration of Africans in slavery as part of a migration project. We can think about the incentives that were used to get white settlers to move to the western part of the United States, also resulting in displacement of Native peoples as part of a migration policy and process. So all of these things are linked in my mind, and we should be keeping all of these things in mind when we think about federal immigration law. But for purposes of a shorter conversation, I'll start by talking about the time when federal immigration policy really crystallizes, when the federal government really assumes preeminence in the immigration sphere, and it really happens in a post-Civil War moment, and it really happens very visibly around the question of Chinese exclusion. And I use this photo to illustrate the notion that the idea of the wall is a perpetual fantasy in American immigration enforcement, one that runs through the ages, and we see that notion of the wall playing out in this cartoon depicting efforts to keep Chinese migrants out of the United States in the late 19th century. So we had this history of exclusion, categorical exclusion of the Chinese, upheld by the United States Supreme Court in a series of cases that continue to be cited by the court and used in thinking about the power of the federal government to enforce immigration law today. And if we can go to the next slide, we can see this notion of Chinese exclusion really over the next couple of decades, kind of beginning in the 1880s and moving through the early 19th century, becomes a bar on immigration from all of Asia. It becomes known as the Asiatic Barred Zone. And then in the 1920s is coupled with a series of country caps that apply to Europe. And you can see the way the map is divided up here. This is a New York Times graphic, contemporary graphic that sort of illustrates the country caps for European countries. And you can see that Great Britain gets the most, right, in terms of the number of visas that are allocated per year. And then you have gradations moving all the way down to countries like Spain, which get virtually none, right? So, and the country caps are tied to the country's composition, the United States' composition at the time that the caps are imposed, but they are part of an overall national eugenic conversation about who is a superior breed of immigrant, who is more likely to become assimilable, and these conversations are steeped in anti-Semitism, steeped in racial bias against Southern Europeans, and so we can see the ways in which the kind of racism of the Chinese Exclusion Act, far from evaporating in the early 20th century, becomes a real fixture in immigration law and animates all aspects of it. At the same time that this was happening, so you had barred immigration from Asia, you had really stringent quotas from many parts of Europe. At the same time that this was happening, you did not have numerical bars for Mexican immigration, but you do have in 1929 the creation of criminal categories for migration, that is the criminalization of illegal misdemeanor entry and later the criminalization of felony re-entry, so using the criminal law to enforce the border as against Mexican migration. So Mexican migrants were still able to come if they met the qualitative bars and if they moved through particular channels. But the criminal law and immigration qualitative bars were also used to exclude many Mexicans during the same time period. So agribusiness was able to take advantage of Mexican labor, but there was also a sort of a valve that prevented, that allowed the country to continue to keep tight controls on migration and use the criminal law system as a backstop for that control. And that is still a feature of the contemporary system. So I think it's worth flagging what its origin is in the 1920s. And then, if we can go to the next slide, that was sort of the immigration regime until the 1960s. And when we think about the 1960s and we think about civil rights, we think about the Voting Rights Act very commonly and the Civil Rights Act of 1964. And I think it's useful to think about the Immigration Act of 1965 in that same category, because what the Immigration Act of 1965 does is eliminate those country quotas that are discriminatory, that favor some countries over others, and adopts a stance of neutrality, essentially, with regard to the allocation of visas. Now, the facial neutrality doesn't always operate in a way that is neutral on the ground. So there are some countries that obviously have higher demand for visas. And so having a country cap that treats Iceland like Mexico is nominally equal, but actually has disparate effects in terms of creating wait times for some people and not others. But I think it's important to note the kind of the ethos of the 1965 Act, which was one of equality and non-discrimination. And I think that should animate the way that we think about contemporary immigration and foreign policy, although it often doesn't. So this is sort of where we are post-1965. And the 1965 Act doesn't make huge changes to the categories of immigrants who are allowed. It does, though, eliminate those country kind of per country caps that are discriminatory. So if we go to the next slide, we can see sort of how most lawful permanent residents come into the country. So the bulk of them, as you'll see, are sponsored by family members. So at the time of this chart, which I think is a 2013 chart, but it doesn't change radically, or at least not till recently, you get a significant chunk is family sponsored, and that's the bulk of lawful permanent residents who are coming into the country. The next largest category on this chart, and a shrinking category in the contemporary moment, and I'll say more about that in a minute, is refugees and asylum seekers. So that on this chart is about 16% of overall lawful permanent resident admissions, and that category is growing smaller for several reasons. The third category here is employment-based visas. So these are individuals who are allowed to enter by virtue of having certain employment qualifications. It often requires high levels of skill, or advanced degrees, I should say, high levels of education, and so is correlated often to economic privilege in the home country. But that is another means, an important means of immigration to the United States. And then finally, there is lottery. For regions that have low rates of immigration in the family and employment category, so this has principally been Europe in the past, and now it is increasingly Africa and Europe that constitutes almost all of the diversity visa lottery. And that's for people who don't have family-based connections or employment-based means of getting into the country, but win the lottery and come in that way. And that is a category that becomes controversial at various points in time. President Trump has expressed his disapprobation of the lottery, and so that's a category that is under discussion when we think about comprehensive immigration reform. When we think about all of these categories of admission, the total number of people admitted to lawful permanent residency in one of these categories in 2018 was 1.1 million people. And when I say that number, that's not 1.1 million people who entered the United States as that time as lawful permanent residents. About half of those people were here in other ways, many of them on temporary visas like H-1B visas, and then were converted to lawful permanent resident status. So about half those people were already here in some form or fashion, mostly on non-immigrant visas, some unauthorized, but then having access to lawful permanent residency. And then the other half is coming in with these visas. As I said, in 2018, that was about 1.1 million people total here and from outside. And that number is going down. So it was estimated that the lawful permanent residence admissions this year would be down by about 11%. And there are lots of reasons for that. And I'll talk about that in just a second. I just want to flag, this number is really tiny compared to the overall number of people who are crossing the borders at any given time. There were 186 million non-immigrant visa admissions in the United States. So these are people who are coming on tourist visas, people coming for temporary work purposes, etc. And that is the bulk of flow across borders, is people moving in these non-immigrant visa categories. Some of them through visa waiver programs from Canada and Mexico, and others with temporary visas that they've obtained. So that's a lot of the flow. But this is the category we're usually focused on when we're thinking about who has the possibility to remain long-term, who has the possibility to naturalize and become a citizen. So I said this category was shrinking numerically, and that the refugee and asylum category in particular was becoming smaller. So I want to talk about those claims, because I think they are things that we should be reflecting on when we think about comprehensive immigration reform. So first, refugees. When we talk about refugees, these are individuals who meet the definition, the international definition of a refugee, an individual who faces persecution on account of characteristics like their race, their nationality, their political opinion, their religion, or some other social group to which they belong. And if they are persecuted by the government of their country or by a person whom the government is unable or unwilling to control, they are a refugee within the meaning of international law and domestic law. And some people are admitted as refugees through overseas processing. So they're working with international organizations. We identify people who are overseas, perhaps in refugee camps and displaced overseas, who meet the definition and are admitted as refugees. And the cap for that is set by the executive branch. So Congress has empowered the executive to set the cap on refugees. During the Obama administration, it was generally around 80, 90, 100,000 refugees per year who were admitted via the refugee program. And President Trump has announced that his number for this year is 18,000. So you can see substantial decreases in the numbers of refugees that the United States accepts from overseas. And this comes at a time when obviously more people than ever are displaced by war, climate change, etc. So this is one reason that we see shrinkage in the overall number of admissions in these categories. The second piece of that refugee and asylum pie is obviously asylees. And those are individuals who meet the refugee definition but are here. So they've come to the border or have been admitted or have come into the country have come to the country with was an alarm that she had. Okay, got it. I think we're safe. It's jumpy times, right? So the refugees are admitted from overseas. Asylum seekers are people who are here at the border, at the land border often, or have been admitted in some other capacity, perhaps on a temporary visa, and then declare their fear about returning, or enter without inspection as they flee from their home country and then seek asylum as a defense to being deported. So again, in order to qualify as an asylum, you have to meet that same definition of a refugee. And what we've seen in this category is two things that are really shrinking that category of asylum seekers or asylees who are being admitted. One is substantive changes to the law. So one of the quirks of immigration law is that you have immigration judges who decide cases and an agency appeal board, the Board of Immigration Appeals, that hears appeals from those cases. But if the Attorney General doesn't like the outcome of those cases, the Attorney General has long enjoyed the prerogative of calling up a case to himself or herself and issuing a new decision. So it is a more politicized adjudication process than is true in many other areas of administrative law as a consequence. It means that the Attorney General appointed by the President has some power to define the scope of immigration protections. And that has been really important in the asylum area because we've seen when Jeff Sessions was the Attorney General, he called up several cases to himself to narrow the ways that the Board of Immigration Appeals had been applying the definition of the refugee definition in cases involving asylum seekers. So, for example, it is now harder to get protection if you are claiming asylum status on the basis of domestic violence. So in the past, it was more straightforward to make out a claim that you were the victim of non-state persecution because the government was unable or unwilling to control the violence that you suffered on account of your perhaps political opinions in opposition to your husband's political opinion, or perhaps your social group status as a woman who fit certain categories. But now it's harder. because of a case law that Sessions has authored. And so that means fewer people will qualify under the asylum definition. So that's a shrinking avenue. The other mechanism by which asylum pathways have been narrowed have been procedural. It's just harder to physically get into immigration courts and make asylum claims than it ever really has been, or at least since the United States enacted the refugee protections as part of its own domestic law. So we've seen this primarily at the southern border, where several things have happened. One thing is that the administration has made the Border Patrol, empowered the Border Patrol to conduct the credible fear interviews by which they do the initial screening of whether an individual will qualify for asylum status. So in the past, that's really been the purview of asylum officers, and now it's really in the hands of the enforcer, the Border Patrol, to make that initial call, and that complicates the process for some migrants. We've also seen the administration categorically attempting to deny asylum status to anybody who enters without inspection. So if you entered not at a point of entry, the position they were taking was that you would be criminally prosecuted and not entitled to seek protections of asylum. This is kind of contrary to assumptions under international law, that one reason you might actually evade a point of entry and come into the interior is that you don't have documents because your country is not authorizing you to leave. That's one of the hallmarks of being someone who has been persecuted in their home country. So this is one point where the administration has clamped down on asylum seekers. And then we've also seen the decision to implement what the administration calls the Migrant Protection Protocol, or MPP, which I refer to as the Remain in Mexico policy, that essentially says that migrants who had passed through Mexico as part of their journey to the United States are required to remain in Mexico during the processing of their asylum claim. And this is where we've seen the sort of emergence of a lot of camps in cities like Tijuana and El Paso where asylum seekers are waiting to have their immigration claims adjudicated on the U.S. side. And there's been litigation around all of these policies. The Ninth Circuit has enjoined the process of criminalizing and denying asylum to individuals who enter at points other than the point of entry. And there is an injunction that may go into effect, depending on what the administration and Supreme Court do over the next week, in the Ninth Circuit anyway, that may go into effect to allow individuals who are currently subject to remain in Mexico to enter the country to have their claims processed. That is up in the air. So when we think about comprehensive immigration reform, asylum and refugee policy then is one of the areas where we've seen this administration actively move in ways that look very different from previous administrations around the questions of how to process asylum claims, what constitutes a valid asylum claim, and what sorts of resources will be deployed in order to discern the validity of asylum claims. And all of those questions, I think, are really important for us to think about as part of what needs reform, right? Is this the right way to go? Is this compliant with international law? Or is this an area where, as certainly some courts have found, the executive branch is acting in contravention to statutory requirements under the Immigration and Nationality Act and in contravention to the requirements of international law? So that's one area that we would want to think about as we think about reform. But other categories within this lawful permanent residence category are also being impacted by current policies that also call out for our attention when we think about the need for comprehensive immigration reform. So some of you probably remember that the president really early in his time in office announced that he planned to ban migration from a number of predominantly Muslim countries. And after a series of months and a series of shifts to the policy, that ban was ultimately affirmed or allowed to go into effect by the Supreme Court in the Trump versus Hawaii.
Excuse me, could you repeat what that?
Yeah. So this was, you might remember the travel ban, the ban on immigration from countries that were on, it was 6, 7, then 8 predominantly Muslim countries that went into effect. Actually, the president initially declared it in January of 2017. That was enjoined in the courts. He put in a revised version in March of 2017. That was enjoined by the courts. And then ultimately, a presidential proclamation was issued later in 2017 that the Supreme Court ultimately decided was valid. And through the issuance of that proclamation, he barred immigration from Iran, Libya, Somalia, Syria, Yemen, and then some people from Venezuela, mostly high-ranking government officials, and North Korea. So the bulk of these countries were predominantly Muslim countries. The president explained that he was hoping to curb and curtail Muslim immigration, which he did through this policy. But the Supreme Court decided that there were valid security rationale for barring migrants from these particular countries, so the ban could go into effect. When we look at the waivers, there's a waiver system that is supposed to ensure that people can still get in if they don't pose a national security threat. Waivers are very hard to obtain, and visas from the countries of Iran, Libya, Somalia, and Syria are down about 80% over what they were in sort of pre-Trump era. So it's had a significant dampening effect on, these would be family members, these would be employment-based immigrants, and also non-immigrant visa, certain non-immigrant visa holders from those countries. So those numbers are also down as a consequence of the ban. Because the Supreme Court said the president is empowered by the Immigration and Nationality Act, Section 212F, to ban whole countries from entry, provided their waiver policies, the president has actually expanded that ban. So just this past month, he extended that ban to Myanmar, Eritrea, Kyrgyzstan, Nigeria, and Sudan. So now we have an even bigger banned zone where individuals have a great difficulty and sometimes impossibility for entering under these categories. So that's another way that the lawful permanent residency category is shrinking. And another, I think, question for comprehensive immigration reform. Congress has obviously empowered the president, whoever the president may be, quite broadly to declare national security crises and to curtail immigration in response to them. And there's not a lot of guidance about how that power is supposed to operate. So the president has broad latitude in implementing that section, and that is what the Supreme Court found when it looked at the travel ban. And I think that raises questions about Congress's role here. Should they be more specific about what constitutes a national security emergency that allows for the curtailment of immigration? Should there be more detail in the statute, or should the president be broadly empowered to act in this way? So that is a question that is on the table. The other area where the president has acted to restrict lawful permanent residence admission, also using the same section of the Immigration and Nationality Act, is through an expansive understanding of what constitutes the likelihood of becoming a public charge. Becoming a public charge has always, or for more than 100 years, has been a basis for barring someone from immigrating to the United States, and it was used by states even before there was a federal immigration policy, so there's a long history of barring people who are quote-unquote likely to become a public charge. But that likely to become a public charge provision has been, up until recently, interpreted fairly narrowly, so really focusing on certain benefits programs and excluding a lot of use of benefits programs as being disqualifying under the public charge bar. But what we've seen with the Trump administration is a more expansive understanding of what it means to be a public charge. And that means that there are more people who might skirt closer might have fewer economic resources, might have availed themselves of some form of benefits, who would now be barred from lawful permanent residency under the Immigration and Nationality Act. So that expansion in who will constitute a public charge, I think, is another area for discussion and for contemplation when we think about comprehensive immigration reform. This policy, this expansion in the public charge interpretation has been challenged in court. It was enjoined by a circuit court, but the Supreme Court intervened to allow the policy to go into effect. So it is currently in effect, even as litigation is ongoing about whether this definition of public charge is consistent with the statute and acceptable. So those are really, they're being litigated as law questions, but they raise political and policy questions about what the appropriate threshold should be for barring somebody on the basis of their availing themselves of an immigration plan, or certain benefits programs. So that is another question that
Can I
this,
ask a question?
yes.
So if an undocumented woman comes and has a child, and she collects services for her children, would that work against her?
So the way this new public charge ban applies, I guess it would depend on the nature of the services, right? For that woman, you know, there's, I should say first, it's difficult to think about the paths that she would have to lawful permanent resident
Right.
status to begin with. But assuming you got there, and then the question is, would that individual be barred by the new public charge interpretation? And the new public charge interpretation, part of what's, I think, worrisome about it is it's broadly discretionary. So accessing any one of a number of listed programs is discretionarily a basis for disqualifying someone for immigration on public charge grounds. And the kind of USCIS will have a broad discretion to determine whether reliance on any particular program in fact signals a likelihood to become a
But
public
if her
charge.
children were born here, they're citizens, and they can access.
The children would, yes, the children are citizens, and they should be able to access services. And in fact, there are lots of services that people should still be able to access without triggering the public charge bar. The difficulty is that the lack of clarity around this rule and the excessive discretion means that people are afraid to access services that might not actually bar them under the public charge bar. So it's both the breadth of the regulation and the lack of clarity about how the regulation will be applied that is actually causing people to eschew services that they might be totally eligible for and that would not actually disqualify them. So it has a broader effect on the ground than it actually has as written.
Thank you.
So that's another way in which these categories shrink. I think those raise questions about, and I just want to kind of looking at the pie as a whole, all of this raises questions about what the substantive admissions categories should look like, what should the allocation be between family and employment, asylum and refugees. But also, obviously, all of the recent developments raise questions about procedure and the scope of executive authority. How do you protect individuals who are in this process? How do you ensure that individuals who are entitled to status are able to access it? And all of those questions have been, I think, made more salient by current developments. So that's what I wanted to say about the categories. I also want to talk a bit about enforcement more generally. So if we could go to the next slide. This is a chart which is really not that helpful because you can't see any dates. On the far left, you can picture 1990, and on the far right, I think this goes to about 2013. And this is spending on the Border Patrol. And if you're looking at the far left figures, the number is about, I think, 400,000. I'm guessing, I can't see the numbers either. And then on the far right, I think it's 4-point-something billion. Is that right?
4.7.
4.7 billion, right? So you can see that there's been a massive increase in expenditures on the Border Patrol over the past 30 years, really striking increases in overall levels of spending. And then if we can go to the next slide, you can see that that spending is only a fragment of overall spending on immigration enforcement, which encompasses obviously not just the Border Patrol, but also other forms of control at ports of entry. It also involves interior enforcement, immigration detention, and a whole host of other enforcement apparatus. And when you look at those numbers, the total for, I think, what is the last year on the chart? Is that 2019? So if you're looking at that, it's about $25 billion spent collectively between border enforcement and interior enforcement by the federal government. Right? We're not even talking about ways in which states and localities might expend their own resources to complement those programs. So we're spending a lot of money on enforcement at unprecedented levels. On enforcement. Some of this is being used to keep asylum seekers or individuals who are attempting to file asylum claims out of the country in the MPP program. We've seen some of this money being directed toward a border wall. Congress actually denied some of the president's requests for funding for a border wall, and here again, we saw that the kind of mechanisms for executive discretion in the law are great. And the president has the capacity to declare national emergencies, again, with little guidance from Congress about what that should entail, and to reallocate military spending through that designation. So we've seen money that was not authorized by Congress for the purpose of a border wall being shifted to border wall by the president, because there does seem to be a tremendous amount of latitude in the statute. So again, questions for comprehensive immigration reform: to what extent should the legislature be more clear about when it intends funding to be shifted to these sorts of situations, particularly in cases where the legislature obviously decided there was not an emergency that justified this funding because they denied the funding as an initial matter. But that's all part of this spending. So funding for a border wall, funding to enforce MPP, and funding in general to increase enforcement predominantly at the southern border, although also at other points of entry, and then in the interior as well. I think the spending suggests that there is an active and growing crisis on the southern border, and I just wanted to look at the next slide just to get a sense of sort of what numbers look like when we're talking about who's being apprehended at the southern border. So if you look at the high point, it really is sort of in the early to mid-90s when you have really high levels of Border Patrol apprehensions of unauthorized migrant attempts at the southern border. So pushing up to about 1.7 million at the peak. And then you see significant reductions. Some of this coincides with an increase in border spending. Some of it coincides with improvements in the Mexican economy and perhaps also with decreased performance in the U.S. economy. Some of it coincides with increasing rhetoric around enforcement that doesn't really correlate necessarily to enforcement. So there are lots of factors that account for the decrease, but one thing that I think should be clear in looking at this is there has been a sort of continued decrease. And if you look at the 2016 period, which is where we were sort of at the election cycle, that's the last bar there, you'll see the green part is Mexican migrants who were apprehended at the southern border. The gray part is non-Mexican migrants, and a substantial chunk of that is actually migrants from Central America, many of whom are raising claims for asylum as they come to the border. That's who's being apprehended. The numbers are really way lower than they historically had been really throughout the 90s and up to 2000. And so there was something sort of strange about the idea that this was an unprecedented level of migration, and one that we couldn't control, and one that raised problems that we'd never seen before, because the numbers just don't match up to that reality. So I think one of the things that we want to think about when we think about comprehensive immigration reform is the extent to which rhetoric about crisis and rhetoric about numbers and floods and overwhelm don't always line up to the empirical realities on the ground, right? And the ways in which, if we wanted to kind of be in that conversation about crisis, it seems like that ship has sailed, right? And so we should be having a different conversation, but we're not having a different conversation. I think that's important to flag for all of us as we're thinking about how we move forward. If we can go to the next slide, we can see that kind of one of the key conversation points around migration and migration control has been migration from Mexico. And it's just worth noting that net migration from Mexico is net flow is below zero, right? There are more people leaving the United States for Mexico than there are to Mexico. And that was the case from 2009 to 2014. So if you think about the rhetoric of the 2016 election and when Mexico sends its people, they're not right. And then you think about the realities of Mexican migration flow, you can see there's sort of a disalignment. We're having a 1990 conversation about the nature of migration in 2016 when the reality of migration is actually very different. The drivers of migration are different because what's driving Central American migrants is not the same thing as the economic interrelationships that were driving Mexican migration in the 80s and 90s. So we're having old conversations and we're diagnosing old problems instead of confronting current realities. And I think we need to think about that when we think about comprehensive immigration reform. Let's talk a little bit about what happened in the 1990s and the 1980s when we did have high levels of migration without authorization from Mexico, partly because we had changes in the law in the 1970s and 1980s that meant that people who were previously lawfully engaged in circular migration to work in the United States were now sort of migrating outside the law. So we had a lot of people who sort of shifted, not because they changed, but because the law changed from being authorized to unauthorized in their migration. And one of the consequences of that and of the closing border is that we had a growing population of individuals who are in the United States who lack authorization and have been here for a very long time. So I think if we go to the next slide, it sort of shows what we're talking about here. So this is from the Pew Hispanic Research Foundation, and what they found is that if you're looking at the overall unauthorized population, the total estimated population, and these are older numbers, this is about 2013, but the bulk of people have been here for a long time, right? 15% for 20 years or more, 16% for 15 to 19 years, 27% for 10 to 14 years, and then kind of 23% for 5 to 9, and only 18% for less than 5. And I think if you look at that statistic, you can see that the problem, to the extent where we think there is a problem of unauthorized migration in the United States, is one that is really sort of a historically created issue, which means that it's something that we could solve through contemporary legalization, right? Because the incoming flow, as we've seen on the charts, as we see in these numbers, is not at anywhere near the substantial levels that we see for the long-term residents. So that, I think, it raises questions about the appropriate use of regularization for long-settled populations, for people who have been here 10 years or more, and have families, and have communities, and have employer-employee relationships, and whether there are ways to answer this question, which is a small question, that disengages it from a broader worries about the future of migration in the United States. We have not obviously moved to offer any form of regularization for this population. What we have done is spent much more money on interior enforcement targeting a lot of these communities. And so that is another thing that I think needs to be a topic of conversation when we talk about comprehensive immigration reform. The Obama administration had several ways for dealing with this puzzle, a Congress that wouldn't move to regularize, but a long-time population in the country that was not an appealing target for removal. And I don't know that the Obama administration's answers were right, but I just want to sort of break down what they did and raise some questions about them too. So one way that they dealt with or tried to deal with this issue was to create priorities. So one example of a creation of priorities was the Deferred Action for Childhood Arrivals program. That's probably the quintessential example of a priority system.
Can you say that whole thing again?
Yeah. So to
that whole thing again.
Yeah. So one of the ways the Obama administration dealt with this was to create priorities. Priorities about who would bear the brunt of enforcement efforts and the money we're spending on it, and who would be sort of carved out of enforcement efforts. And DACA, Deferred Action for Childhood Arrivals, is one example of this, right? So the president decides that there's a group of people that will be deprioritized for removal. That's DACA, right? It says, yes.
The ends of your sentences are dropping off.
Okay,
So
sorry.
right before DACA, one saying and point you were making dropped right off. Can you go back and say the whole thing again? I'm sorry.
Yeah.
Speak right into the microphone.
Yeah, that might work
Let
better.
it there.
Okay, there we go, sorry. Thank you. Okay, so one of the ways that the prior administration tried to deal with this issue was to create priorities in enforcement, taking some people sort of out of the enforcement priority list and then raising the priorities for others. And one of the ways they took people out was through the Deferred Action for Childhood Arrival program, or DACA. So DACA basically says if you meet this criteria, you've been in the country for at least 5 years, you've been here since you were under 16 years old, you have completed high school, you have no disqualifying criminal convictions. If you meet that criteria, then we're not prioritizing your case for removal. You can apply for a work authorization, which we're permitted to give you under the regs, and we will not remove you. Why? because we have lots of potentially removable people in the United States under the law that Congress has enacted, but not resources to remove all of those people, and we're going to create a priority system. So it deprioritizes the individuals who qualify for DACA. As we know, the Trump administration was not pleased with that solution, and they have since subsequently announced their intention to rescind DACA. And that is something that is currently being litigated in the courts, and we can talk about the litigation more if people are interested. But that's one way that you could prioritize or not. Another way that the Obama administration said that it would prioritize was it said that it would prioritize individuals who had criminal convictions. And so, yes.
How many people fall into the DACA category?
There were at its height over 800,000 people who were enrolled in the program. That number has dropped off. Some of it's because people find means to gain lawful permanent resident status, a small fraction of that. And some of that is because people become disqualified for the program. Perhaps they have contact with the criminal justice system that disqualifies them. And some of it, I think, is distrust of the system that emerged in the sort of post-Trump era when people began to worry about what would happen with their data. So the number now is closer to 600,000. We've seen it. So that was one way of prioritizing. Another way of prioritizing was to prioritize people with criminal convictions. There's a lot of conversation in criminal justice reform circles about how effective the criminal justice system is in choosing who is should be a priority. So we can think about the ways that there are conversations around racial profiling, the racialization of mass incarceration, and about the ways in which enforcement may fall more heavily on some communities. And if we couple that with a prioritization of criminal record as a basis for removal, we can see the potential for problems. And that is one critique of prioritizing individuals who fall into the broadly defined category of criminal, removable on criminal grounds. But that was another way that the Obama administration prioritized. When the Trump administration came in, they said that they didn't want to adhere to these Obama administration priorities, that instead the priority was really anybody who was removable. And so we have seen a move away from a priority system in favor of a kind of more broad use of whoever comes into contact with the immigration enforcement system as priority. One of the other things we've seen as a consequence of increased enforcement is increased detention. Some of you have talked about your visits to Adelanto detention facility. So if we can go to the next slide, we can see the growth in immigration detention. Again, these numbers, you can't see them. But I think the first year is what, 1994, and we have average daily population of about
7. Is that million?
No, that's just like about 7,000.
7,000.
So about 7,000 people detained on any given day in 1994, and now that number is much higher, closer to this chart. It doesn't go up. I think it does actually. It goes up to about 55,000 now.
45.
It's higher than that. Yeah. So it's about 55,000 people detained on any given day. So that's civil immigration detention. These are not people who have criminal convictions serving time. These are people whose cases are being processed for removal, and so they're not being criminally punished. If they were convicted of crimes, they have already been criminally punished. They are separately in a civil immigration detention system that is growing. It's largely privatized and it is getting larger. So that's a lot of money to keep people detained. And another question, I think, for comprehensive immigration reform is, do all these people need to be detained pending the adjudication of their immigration cases? Lots of people are. So we should raise the question about, are the categories for mandatory detention good ones, or are they overbroad? And is detention really necessary in a lot of cases with people who have been long-standing members of their community and really aren't going anywhere during the pendency of their removal proceedings? So that's another comprehensive immigration reform question.
Excuse me, I
Yes.
have a good question on detainment.
Yeah.
Isn't it true that they're not required to stay in a detainment center if they don't want to.
No.
For example, they can go back to their home country.
Yes, so if they wanted to not fight their immigration case, they could opt to go to their country of nationality. So the people who are often in detention the longest are the people with the strongest claims to remain, right? Because they think they have a valid case for removal. They often have strong equities that sort of favor remaining. They have family members here, they've been here a long time. And those are the people that you actually see sitting in detention facilities for the longest, in part because of the strength of the claim. So that's what makes this a sort of a hard system. But yes, I think for people who are recent arrivals who are detained, often the decision is rather than to wait in detention and seek adjudication of the case, they would return. But if they're afraid to return, if they fear death upon their return, criteria that might qualify them for asylum or Convention Against Torture relief, sitting in detention might be the preferred option. And the question is that the appropriate option in cases where people are in fear of death or persecution? Yeah.
Do you know what proportion of people in detention are parents who have children who were born in America?
I don't actually know statistically. No, I don't know. There are certainly a lot of people who have family members in the United States, but I don't know percentage-wise. And that would also fluctuate because the composition of immigration detention changes over time. And I don't have a good ballpark figure for you, but it's a really good question. Yes.
Can you speak to unaccompanied children who arrive?
Yeah, so
What happens to them?
So I can talk a little bit about, and I won't go too far into the weeds, but they are, for unaccompanied children who arrive, they can be detained as well. They are not subject to detention by Immigration and Customs Enforcement, which is responsible for detaining adults under the current system and ERO. They are instead under the jurisdiction of Health and Human Services, the Office of Refugee Resettlement. So it's a different agency that's responsible for minors under the statute. And I think in theory, the idea is that it is more humane in its approach, more gentle in its approach because you're dealing with children. But there are a lot of children who are detained in kind of jail-like facilities if they meet certain categories. So some individuals are released, but ORR is not required to release them if they can justify holding them. So there are children who are in detention and some children who are in detention for quite a long time. If ORR thinks, for example, they pose a risk of being a gang member, that would be one reason that they might put them in a secure facility and not release them, even where they might otherwise be entitled to release. So there's no constitutional right for them to be released. There is only the kind of due process right that they have to raise their claims about being released, but ultimately the government can make a determination that they're going to hold them, and sometimes they do for long periods of time. But in many cases, children will be released because it's not in the government's interest or desire to detain them. They'll be released to family members. They'll be released to other individuals who are able to care for them. But there are kids who are detained and can be detained for lengthy periods of time. When they are detained, they're subject to the restrictions of the Flores settlement, which arose out of litigation in the 1990s. It's supposed to be more child-friendly. They're supposed to have access to educational opportunities. So there are restrictions on the conditions under which children can be detained. The extent to which detention centers comply with those restrictions is a source of more litigation and investigation.
Question?
Yes, sorry, I'll go. Yeah, so I just have two more quick points and then I'll go to questions. So I don't have much more to say since we're having conversation, we should have conversation. Two other things that I'll say really quickly. One is, or not really quickly, I'll say it really slowly. Two other things. So I guess thing one is, well, we can put up the next slide and we can see that this is not thing one. This is just information about the prosecution for immigration crimes. And again, what's the first year on there?
1998.
So in 98, about 21,000 people a year were prosecuted criminally under federal criminal law for immigration crimes. And you can see that that number is now in excess of 108,000 a year. So, and it is really the majority of criminal prosecutions under federal criminal law. So a lot of federal criminal prosecutorial resources are going to the prosecution of primarily misdemeanor illegal entry and felony reentry. So crimes of migration, pure crimes of migration. So that's another question, I think, for comprehensive immigration reform. What is the appropriate use of the criminal law? When is it appropriate to criminally prosecute? And when are other mechanisms more appropriate? And then the next slide illustrates the way in which localities have been integrated, states and localities have been integrated into the enforcement process. Because now if you have contact with a law enforcement official at the state or local level, so local police or a sheriff's officer, your fingerprints upon arrest are run through a database that the Department of Homeland Security accesses. And then sometimes they decide they're interested in the person and they will communicate with the locality and ask them to hold. There's been a lot of litigation and questions about the states and localities, what they're required to do in those instances, whether they are in fact required to hold, whether they have the capacity to push back and release, and under what circumstances. And that is obviously the source of ongoing litigation that we can talk more about in Q&A. California has enacted legislation that seeks to limit the extent to which it cooperates with the federal government. The Trump administration has pushed back by threatening to pull back law enforcement block grant dollars as a consequence for those choices, and there's been litigation about that as well. So we can talk more about that if people want to talk about that. The final thing I wanted to talk about was just kind of the sagging immigration infrastructure. So we have lots of people who are being arrested, lots of people who are being detained, lots of cases being filed, and huge backlogs in immigration courts. So the immigration backlog is about 1 million cases now. Immigration judges are under direction to process 700 cases a year each in order to try to work through this backlog. And so there aren't a lot of resources that are flooding to grow out the immigration judges' bureaucracy. But there has been a lot of resources that have been put into increasing the enforcement bureaucracy. So you can see how lots more enforcement means lots more cases being funneled to a court system that is pretty overburdened. And so cases are taking a lot longer to decide. So if we think back to the detention question, detained cases have priority because they are sitting in detention. But even detained cases with priority take a long time to process in a system that is this backlogged. And so another question for comprehensive immigration reform is, what do we do with the adjudicative bureaucracy that is not processing these cases very well? What sorts of resources are necessary to process cases? And are they a match for the ways in which we have prioritized and funded enforcement? So I'll stop there because I see people have lots of questions and we can just talk. Part of the scheme was to criminally prosecute individuals who were entering without inspection. And as part of that process of criminal prosecution, since they're criminally prosecuting the parent, children were separated. And in some cases, not in a way that allowed them to easily be reunited with family members.
But I guess now you're pointing to a more fine question is, have the parents of those 500 about, whatever that number is, been identified or are they lost?
So in some cases they are lost. They're lost in the sense that there's no way that the system has not been able to connect them up with a parent, right? So there was not very good record keeping in some of these periods of separation, which is sort of mind-boggling as a mom, right? I would kind of want the government that is now empowered to do anything it wants with me and my child to at least make sure that that information was
You expect
carefully.
the government to be able to connect the dots.
Yeah. So this obviously has resulted in litigation. Judges have ordered families reunited, but there have been some limits to the capacity of the government to reunite because they lack the records necessary to actually reunite kids with parents. Yeah. Okay.
Could you talk about any legislation which is pending in Washington and tell any way the legal women voters can help get a good bill through?
Yeah. So the question was, Washington and any way that political activism could sort of move those bills through. So I think that the problem that we're facing is the Trump administration doesn't seem likely to be signing off on any legislation that sort of broadly fixes a lot of the problems that we're talking about. One piece that we might think about, the Supreme Court is going to decide the deferred action case any day now, presumably by June. I don't have a great feeling about the way that's going to be resolved, but even if they resolve it in a way that keeps deferred action in place for now, it is a very tenuous program, an executive program that the executive branch doesn't really like or support. And so it seems like that is an easy case for activism around legislation that would give individuals who are in the deferred action category, and maybe a broader swath of individuals, a much more permanent status through congressional legislation. That seems like easy, low-hanging fruit. Nothing seems easy anymore around immigration, but that to me is perhaps the easiest. And I think the DACA litigation and a Supreme Court decision in the DACA litigation might actually be a spur to action for Congress on that front.
So speaking of comprehensive immigration reform, let's say you are the chair of the House Judiciary Committee or whichever committee it is, and you got started drafting a bill. What would be, from your point of view, like the 3 or 4 primary building blocks we would need in new legislation to accomplish comprehensive reform?
I think you would start by looking.
Repeat the question.
The question was, if we were thinking about sort of 3 primary building blocks we might look to if we wanted to enact comprehensive reform, what might we start with, right? And I think I would probably start with the question of what kind of redress do we give to long-time residents in the country, right? So that's the question of legalization. And I have a very sort of generous and capacious view of who that should apply to. That is, that's subject to political negotiation, but I think that is a critical question. Because as long as you have a group of long-term residents here whose status is as unresolved as it is, then your enforcement can really never be rationalized, and you can really never have humane policies in terms of interior enforcement. So that's a really important piece. I might also look to the enforcement bureaucracies to create greater checks on their power. They have fewer checks than a lot of other policing agencies have. This is true of the Border Patrol and of ICE and of detention facilities. And so the executive branch has a lot of capacity to conduct oversight or not in those spaces, and I think a lot more legislation that paid a lot more attention to the conditions under which enforcement happened and the conditions in detention. And I would hugely scale back on detention. I think most of the people who are in immigration detention don't need to be there. So I think we could save a lot of money, and we could rationalize the system, and we could maybe spend more money on immigration courts, and on naturalization, and on integration, if we were not spending so much money on unnecessary detention for huge numbers of people who are in the system. So those are some things I might work on.
But in the detention, though, there's the other situation of these are private firms, so firms working through legal mechanisms
That's right.
are another force to be considered,
That's
because
right.
they have power too to continue this, or to push for a continued detention because they have a vested interest.
Yes, they definitely have a vested interest, and they have a particularly vested interest now that there's been sort of pushes on the criminal justice side to cut sentences, to decriminalize drug activities, right? As you reduce the number of prisoners on one side, the demand for filling bed space on another only increases, and I think the private detention actors have been very good about advocating for their interest in that space, and that's why we see this expanded use of what I view as largely unnecessary detention. Yes.
During the Democratic presidential debates, there was
Such as they were, yeah.
there was a difference of opinion about criminalization of misdemeanor immigration, and so I'd like to know your thoughts about that, and also about what makes a misdemeanor unauthorized immigration and a felony.
Yeah.
And a felony.
So the way the law currently operates, basically any entry without inspection can be a misdemeanor offense. Overstaying your visa, interestingly, is not a misdemeanor offense. So there's a lack of parallelism depending on mode of entry. So that's an interesting feature of the sort of racial and anti-Mexican origin of the law, right? It's about the police officer.
And you don't stay.
Yeah, so that, there's that piece. The felony provision applies to individuals who have previously been removed and have and return. And often, those people fall into a number of categories, but one of the most common is people who have strong family ties on this side of the border, right? That's why you would risk returning, notwithstanding a potential felony sentence. So that's, given the origins of the criminal pieces of the immigration law, I think this broad use of federal criminal prosecutorial resources to sort of manage crimes of migration seems like not a good plan. It seems like these are, to the extent we want to kind of have offenses here, they're civil offenses, we have a civil system for dealing with that. And I think that we are broadly over-criminalizing. If you're worried about things like exploitation through smuggling, there's a crime for that, right? There's actually a federal criminal provision. Very few people are prosecuted under that offense, right? That might be an appropriate offense to retain if you think that you are preserving human life and dignity through that criminal provision. But that's usually not what we're talking about when we're looking at those numbers of who's being prosecuted for immigration. Sorry. I was going to say, should I get someone who hasn't spoken? And
Yeah, I'll be brief.
Okay.
I love your idea on getting more courts because I just think there's just so many kids and so many people who really need justice. And how, as an attorney who's been practicing for 20 years, how can I apply to become like one of those judges to be able to help out with the system?
So they do post ads, right? So you can actually look at the Executive Office of Immigration Reform website. They post ads for judges. And they hire them occasionally, a lot of times out of the immigration prosecution side. So it's often people who work in ICE who then wind up getting hired as immigration judges.
Okay, so I have to be an
But
insider.
you're not, but not everybody fits that bucket. You could apply, you could become one, but there just aren't very many of them relative to the number of
And
cases.
they really do increase. Thank you.
I think here.
Oh, sorry.
Oh, go ahead, sis, Jim.
I'll go here and then here, yeah.
Thank you. So a couple of questions. One is on the legal side. You touched on the international law regarding immigration.
Yeah.
And I infer from what you're saying that it's being ignored and there's no repercussions for doing so.
Which is often the case under U.S. law.
So they're just saying, I don't care what the international law is, we're doing what we're going to do.
Yeah, so there are restrictions on the detention of asylum seekers that I think the U.S. has been in pretty clear violation of for decades. That hasn't really changed the situation. With regard to the way that we're requiring asylum seekers to stay outside the country to have cases processed, that pretty clearly is objectionable, and certainly in some cases under international law, but there's really no recourse for sort of raising an international law claim that U.S. courts are cognizing. So the only way to raise a claim is to raise a due process claim that will be cognized under the U.S. Constitution, or a statutory claim, which is how these claims against the migration protection policy have succeeded, because there are arguments that what Trump is doing is actually contrary to what Congress has required under immigration law and the treatment of asylum seekers. Those are the claims that have had traction. International law claims might work in international courts, the Inter-American Commission, but they don't have a lot of traction on the ground in the U.S. legal system.
And the same thing about speedy trial. There's no enforcement of that, or doesn't apply.
It does not apply because deportation is not considered criminal punishment. So speedy trial, bail protections, et cetera, that might apply in the criminal context don't actually apply to civil immigration protection.
Right.
I would like you to address the idea under comprehensive reform of quotas. I had read once about a more fair way would be a percent based on demand,
Yeah.
but we never ever hear about that.
No. Yes, I think that's absolutely right. If you're thinking about sort of facial fairness, then perhaps sort of assessing overall levels of demand and tailoring visas in a way that that meant that every country got the same percentage with regard to demand. And that might raise some math problems, but nothing that couldn't be solved, right? Nothing that couldn't be finessed.
No algorithm, something in an algorithm.
Right. And it does seem that that would be more fair. So one of the things the current system does do is it means that Mexicans who are waiting to reunite with family members have sometimes ridiculously long wait times to move through those legal channels, right? So, when I say ridiculously long, I mean like 10, 15, 20 years to get their visa because their visa number is
Doesn't it
way
even
down on the list.
reset at some point?
It doesn't reset, right? So it just keeps getting longer unless and so you have long wait times there. You also have long wait times for some immigrants from India for certain of the employment-based categories, and immigrants from China for some of the employment-based categories. So demand and supply are not in alignment, and the result is that the real losers here are Mexico, the Philippines, China, and India, but there are other losers on the list as well, and those individuals wind up with much longer wait times than their counterparts from other
Do you
countries.
think that there's any way that our government will address it in that regard?
I think it should be part of the conversation, right? How do we allocate visas in terms of supply and demand? Isn't there a more fair way to do this? Shouldn't there be equity of wait times across countries? Is this really unfair? I think those are valid points of conversation, and they do periodically come up. But so do things like, let's just cut the whole system out. So who knows?
Brown, and then right there, yes, and then over here.
I'm sorry, I'll let you do that.
You
You lead a lot, thank you.
Right here.
Okay.
You mentioned two different agencies that are handling both children and adults that are coming across the border.
That's right.
Does that play into the separation of kids from their parents?
So, as a technical matter, it shouldn't, right? But I think effectively it does. So, as I said, ICE is responsible for detaining adults. ORR is responsible for the detention of children. So what happens if you come as a family and you're an adult and a child? Under the Flores settlement, children are supposed to be released quickly unless the government can make a case that they are subject to continued detention. So kids should be able to get out pretty quickly. 20 days really. If there's, you've got a 4-year-old who doesn't pose any sort of security risk, they should not be in detention for more than days. And the parent might be subject to indefinite detention pending the resolution of their claim. So you have sort of two different trajectories. And the result has been sort of the choiceless choice in some cases of either being part of the family detention system, being in family detention so that the child is detained with the parent. And then when the child is timed out, making the decision that the child is going to be separated from the parent because the parent has no right of release, right? And the courts have found that parents don't have a right of release just because the child has a right of release. So that becomes another inflection point for separation because the parent may still be subject to detention and the child may due for release, and that becomes a point where separation can happen. And the administration has basically said if the parent wants to sort of waive the child's right and keep them with them in detention, they can do that, and that's the solution to the separation. So you have the choiceless choice of, family detention or separation.
Okay, right here, this lady, and then.
Given the current political climate, I'm interested in your thoughts on how we can possibly move toward any kind of comprehensive immigration reform.
So, I'm really leery about answering that question. I was a person that thought we were going to have comprehensive immigration reform in 2013 and in 2006. I mean, every time I get all optimistic. And I think, so many compromises have been made. There's been so many trade-offs made. There's been so much concession to more enforcement that surely this will be the point around which everybody can rally. And the answer has repeatedly been no. So I don't know what it takes to have a rational conversation about a depoliticized and a factually grounded conversation about immigration anymore. I do know that I think it's really important to sort of foreground the stories and the activism of people like the recipients of Deferred Action for Childhood Arrival, who not only are themselves sort of quintessentially the kind of citizen that you want, but who also are advocating for their broader that I think are different from the ways that Washington insiders have advocated for immigration reform in the past. So I think listening to them and their activist voices and the way that they frame the question might be a way to move us forward.
Right here. The late, no, Sandy.
Hi, yeah, I was offered many thousands of dollars to marry a younger man who was kind of stuck in the immigration process from an Asian country. Would it have helped? I told him I didn't think it would.
So, as a legal matter, so as a legal matter, the answer is that would be problematic immigration fraud. So there were all kinds of questions. If you are marrying for purposes of the immigration benefit, that is legally prohibited under 1986 law. So it's good you didn't do that. The answer is marriage does in fact work and help. The problem is I think people think it's a lot more straightforward than it is. So if you have been in the country out of status for more than a year, which is a lot of people based on the chart I showed you, you are technically barred from admission, which is what you need to get the green card, for a 10-year period. So even if I'm unauthorized and I marry a citizen and I go to USCIS and I say, look, now I'm eligible for the visa as the spouse of a citizen, they may very well tell me, well, look, you've been in the country for more than a year, 10-year bar, go back to whatever your home country is and wait it out. And there are waivers for that. Different administrations have been more or less generous with those waivers. We're in a moment of not generosity when it comes to those waivers, which means that marriage is by no means a guaranteed path to remaining.
Carolina, right here.
Can you talk a little bit about immigration locally, SB 54, and what cities and counties can do?
Yeah, so we've seen a lot of action at the state and local level, and this has also been spurred by a lot of youth activism, right? The idea that the federal government isn't moving, nothing's changing, there's no comprehensive reform, and so what can we do at the local level to make things better? And one of the ways that I think they've tried to make things better is to create spaces where they feel like their police are working not for the immigration enforcement agencies, but for public safety purposes. And so the idea behind a lot of this legislation, both at the local level and the state level, is to limit the circumstances under which the state will comply with federal requests for holding people, for detaining people, and with federal requests for information about when they're releasing people. So that's one space where we've seen a lot of local activism, trying to create spaces where cities or the state can say our agents are not acting as agents of immigration enforcement, they have a different mission. So that's where we've seen the activity. We've also seen pushback in that space. So we've seen the Trump administration saying to municipalities, we're going to keep your federal law enforcement block grants if you don't fully participate with our requests. So this is it's a hotly litigated area. We saw the Ninth Circuit saying that the Trump administration couldn't do that, but we also just saw this past month the Second Circuit saying that the Trump administration could in fact threaten the state of New York with the pulling back of certain law enforcement block grants if they did not fully comply with the requests of the administration for cooperation. And so we now have a circuit split on this question with the Ninth and the Seventh going one way and the Second Circuit going the other, and a really live question now being litigated about whether the Trump administration can threaten to and actually withhold large federal block grants for law enforcement if localities and states decline to comply with all of their cooperation requests.
Can I quickly, there's a difference between a cooperation request and a legal warrant. So,
Yes. Yeah, so there's actually law, a Fourth Amendment case law that suggests that localities can't detain people on a request, right? Because they don't have, once their own law enforcement capacity is over, right? If they process somebody, they dealt with a state or local offense, and they no longer have cause to hold them, if all you have is a request from a federal agent, right, we're interested in this person, please hold them, that's not probable cause for the continued detention. And numerous courts have held that, right? So you have a Fourth Amendment problem. When a federal agency without a warrant asks a locality to continue to hold somebody for whom there is no warrant. And damages have been paid by municipalities that have held people in excess of the time that they had their own authorization to hold. And so part of what California and other localities are doing is saying, we don't want to pay for that, we don't want to pay damages, and we don't want to be committing rampant Fourth Amendment violations, so we're not going to hold people on your quote-unquote request, right? You need something more than that for holds. And so this is the sort of catch-22 box that the New York litigation puts these jurisdictions in, because the Trump administration has said, comply with all our requests. And courts have said, don't comply with that request, it's a Fourth Amendment violation. So there are real problems I think this creates for states and for localities as they try to figure out what their legal obligations are to the people they police and to the federal government from whom they receive block grants. There are real tensions in what they're being asked to do.
All right, gentleman here, and,
Will you share copies of your slides?
Yeah,
Thank
yeah,
you.
absolutely.
Sorry.
And then you can read them, right?
all right, this is the second question. Are we
I
finished
don't know
most of
what
the
time.
first questions, and then we're almost done everything in the first question?
Yes.
Rhoda.
We just read in the paper about your $5 million grant. Can you tell us what you're going to be able to do with that?
Oh, I wish I knew. I wish it were my $5 million grant. So the UCLA School of Law received a $5 million grant for work on immigration, both law and policy. We have a clinic that provides direct services, and one hope is that we'll be able to expand the direct service work that the law school does. And then I think the other idea is to really move the law school in a direction where it can be a kind of a key player in thinking about immigration policy, both at the state and at the national level. We have lots of immigration experts on campus, not just at the law school, but also around campus. And obviously Los Angeles is a rich environment for people who are doing work in the area. So the idea is to be able to bring people together, to have conversations with law enforcement agencies, with affected communities, with experts, and try to, from that, be a source of guidance, writing policy papers, working with representatives, thinking about law and policy change. So it's all very nascent right now. The money, I don't know how those gifts work, but I know it's a long, drawn-out process of approval and rollout. I haven't seen any money. But the money, I think, is there, and the idea was that this is a critical time to really bring expert voices to bear here in an area where there are so many people who have so much experience and wisdom on this issue, and this just seems like the place to do it.
So, yes. See what she's going to do. Something, I mean, UCLA is great, and I think with the money that Rhodey mentioned, the $5 million, you will be involved in that, I'm sure, and there's such great promise. You are just full of information, expertise, knowledge, and I think this has been really enlightening for all of us. Yeah? Yeah. Thank you.